Okay, we will start. So what we will do is, in this session I'll talk about the Constituent Assembly briefly. Okay, you won't get questions. In case if you get a question based on, it is based on cabinet mission plan. So in case if you get a question, we will cover this quickly. It is there in Lakshmikant also. And then we will discuss about objective resolution. Objective resolution actually is the reflecting the philosophy of the constitution. What is the constitution and what and how it should look like, and everything is there, like the federal structure, fundamental rights, protection to minorities and the weaker section. Everything you will see in the objective resolution. So we will quickly see that Constituent Assembly and objective resolution. Okay, and after that we will see some concepts like federal versus unitary setup. Okay, and then we will see written, unwritten constitution. What is the difference between written, unwritten? Like then we will see flexible, rigid. Okay, whether we have a flexible constitution or a rigid constitution, or we have a mix. So this is what we will see, and then if possible, if time permit, we will discuss about the different types of majority. Like now onwards, when we proceed further, you will see in some cases simple majority, you will see special majority, you will see effective majority, absolute majority. So we will try to clarify all these different terms. Okay, so we will start with this Constituent Assembly. As I have told you, okay, it is there. I'm not going. Yeah, why? Am I audible? Can all of you just clarify this? Some of you.
Yes, sir.
Yes, Jeevan, actually for others, I'm audible very clearly. So it may be problem from your side. Can you just log out and log in again once again? So I'm audible for others. Just log out and log in again. Okay, so Constituent Assembly entire details is given here. What I'll do is I'll quickly go through all these. So based on which plan? It is basically based on the cabinet mission plan. So based on that only Constituent Assembly was set up. How many members? See guys, nobody is going to ask you how many members and all, but since it is there, I will be discussing quickly. 389 members initially. Okay, so out of which, how is it divided? This 389 is divided to 296. They will be elected from the provincial assemblies. Okay, so 296 will be elected from the provincial assemblies. And what about the balance? Rest of the members, this rest of the 93 will be nominated by the princely states. So provincial assembly elected 296 and princely states nominated. So initially these princely states were not interested in joining the Constituent Assembly, but later they have joined it. Okay, and based on that you will not get any questions, so we will skip this area. So this, just remember this 389, this number. Okay, so it was set up on November 1946, and based on what criteria this number? It is based on one will be for 1 million population. Okay, so like 1 for 10 lakh people, one member for the 10 lakh people. So that is how it is actually divided. Okay, now when was the first meeting? First meeting was in 9th December 1946. And who was the president in the first meeting? The president is actually Sachidanand Sinha. Okay, so Dr. Sachidanand Sinha. He was actually a temporary president, and for 2 days only. And then after 2 days, the next meeting, the second meeting was there. That is on 11th December 1946. And the permanent president was elected on the second meeting. So who was the permanent president? Dr. Rajendra Prasad. Okay, so I'm expecting these small points you can write down along with me, even though you can see all these things are here in detail it is given, but still these important points you can quickly write down along with me. Okay, so Sachidanand Sinha was the temporary president for two days. See, as per the convention, the oldest member, okay, French convention, he was selected as the president. And then after 2 days, when the second meeting came, the permanent president was actually elected. Rajendra Prasad was the permanent president. So after these 2 meetings, once the president is elected, now comes the first session. Okay, so in the first session, when is the first session? First session is from next second day from here, 11th. That means the 13th of December 1946. So this is when the first session was held of this Constituent Assembly. So when I say first session, what does that mean? The constitution making actually began from here. Okay, so this is a situation. The first president, you need to know, the temporary, this was temporary, and this is a permanent president, Rajendra Prasad, Dr. Rajendra Prasad. And after that, first session was held on 13th December. From there, the constitution making actually began. Now guys, this is 389 members in the beginning, but after independence, what happened? 90 out of this went to Pakistan. So how many left out? 389 minus 90, that is 299 left. So this 299 members actually made the constitution. Okay, and here you will see some major committees, and this members will be divided into different major committees. Minor committees are there. There are 13 major committees, very important. You just need to go through that. I won't be able to discuss all the committees at this point of time, but I have seen in the previous years, not after 2010, the previous type of questions that they used to ask us from this kind of committees also, they used to ask question. In between, in 2013 or 14 also, they have asked this question. So kindly go through that committees, at least the major committees. That is very important. You need to have an idea. At least just before the examination, you need to go through that. It is very difficult to remember the names and the head and all those things, right? So, but some of them you will be, it will be easy to remember, like where Jawaharlal Nehru was the head, where Rajendra Prasad was the head, like that you can remember. Then one more, that is the most important one, drafting committee with 7 members. Who was the head of the drafting committee? Dr. B.R.Ambedkar. So what is the job of this drafting committee? What the drafting committee will do is they will draft the constitution. So all these committees, the major committees and the minor committees, all these committees will come up with propositions, right? So they will come up with recommendations like this feature should be there in the constitution. Okay, and this has to be there. So it has to be based on federal setup, the protection for minorities, fundamental rights. So all these will be given by different recommendations will be given by different committees, and that recommendations will be codified by the drafting committee. Okay, so the drafting committee was formed on 29th August after independence 1947. So the drafting committee was formed on this date. Just note down if it is required. I think this is not there in the Lakshmikant. So 29th August 1947, and the first draft. So their job is basically to draft the constitution by taking into consideration all the recommendations which are given by different committees. So October 1947, the draft is prepared. So once the draft is prepared, then what they will do? They will go for debating whatever changes is required, and then voting, and all these processes there. So once this draft is prepared, see, hardly in 2 months, right? August, September, October, the draft is ready. And once the draft is ready, and when it went for voting and the changes and all these, it was finally adopted and enacted on 26th November 1949. So the constitution was finally adopted and enacted on 26th November 1949. And so when I am saying this, this is enacted or adopted. It got enforced from 26th Jan 1950. You know why this date is chosen and everything, because this was the day which was celebrated as Independence Day in that after that Lahore session of 1929. Okay, so here what is the difference between enacted and enforced? When I say enacted, it means to make. So the constitution was made by this date, it was ready by this date. After all voting and drafting and everything, it is ready, but it came into effect from this day, 26th of Jan 1950. So I hope this is clear. That's about Constituent Assembly and the major committees, guys. Just go through this. So this is what I've discussed: 389, 296, 93, right? Of how all these things are there. Now when you read, you will understand it better. Now next I will discuss about objective resolution, but before that you can even go through the committees, the major committees, like you can see here So these are the major committees. Just go through this. At least who was the head of this, you just need to know. Okay, and then this is a drafting committee, 7 members. You need to know the 7 members. Okay, don't forget these names. Okay, that fact you need to remember. Now what I'll do is I'll quickly go through some of those provisions which are taken from different countries or from Government of India Act 1935. As I've told you yesterday, when we discussed about 1935 Government of India Act, some of the most of 60% of the constitution is directly coming from 1935 Government of India Act. Okay, so if you look into this, mostly the constitution is prepared or drawn from 1935 Government of India Act, but we cannot do just like that. No, if we have done that, then what is the authority, what is the question of, it is something which is prepared by the British and we are following the same. That's not accepted. So what they did is they have gone through all the good practices of different countries. Like you will see a lot of things are borrowed from US. Okay, and then UK, obviously, like the parliamentary system and all. So I'll quickly go through. This is there in Lakshmikant. Again, you need to see that because you can expect a question directly. The good thing about these questions are these will be one word. You know it or you don't know it. If you know it, you will directly get that 2 mark. That's a great advantage. So these are the areas which you cannot afford to miss. Which is from which constitution or which country. Okay, like for example, if you see federal form, from where it is directly from 1935 Government of India Act. So if you remember yesterday, I've discussed about this, that there was a provision of federal setup, right? But when I discussed about federal setup, I've discussed with you the government at the 2 level, right? So 2 governments at the 2 level, like at the center, then at the state also. But at the center, I have told you, here again you will see diarchy, rule of 2. What is that? So there will be a viceroy. At the same time there will be some elected Indians. So viceroy will be handling the reserve subject and the elected Indians will be handling the transferred subject. That is different thing that I have discussed yesterday. But along with that, we have discussed about the federal setup. Federal setup means rule of 2 at the different level. Diarchy means rule of 2 at the same level. 1919 rule of 2 at the same level. Which level? Provincial level. 1935 rule of 2 at the center level. At the same time, there is a federal setup which was given in that. Okay, so federal concept was borrowed from 1935 Government of India Act. Similarly, what about Office of Governor? Again, from 1935 Government of India Act. Emergency power. Okay, all these we will be discussing in detail in the coming session. So I'm quickly getting through all these things. These emergency and emergency powers, Office of Governor, this federalism. Okay, what kind of federalism that we follow? Is it similar to US or is it a different version? Or is it quasi-federal, or is it federalism sui generis? Don't worry about all those things which you need to write in your answer in mains. That we will be discussing in the coming sessions. Here I'm just telling you from where which provision is taken. So Office of Governor, 1935 Government of India Act. Again, emergency, 1935 Government of India Act only. What about suspension of fundamental rights during emergency? That is from Germany. What is that? Suspension of fundamental right during emergency. So taken from Germany. I'll tell you guys what are the fundamental rights. In fact, I'll be spending 2-3 sessions for fundamental rights. This is if you are studying polity, more than from exam point of view, you should be having very good knowledge about the fundamental rights. This is going to be very important, and we will discuss all the cases and whatever is required in a much better way. Suspension of fundamental rights we will discuss when we discuss about emergency, when we discuss about national emergency. What are the fundamental rights will automatically get suspended, what will be suspended with laws, everything will be covered there. Okay, but understand this is from Germany. What about rule of law? Rule of law from UK. What do you mean by rule of law? Nobody is above the law. Everybody have to work within the law. You have to follow the rule of the land. Even it was actually introduced in India by which Governor General? Lord Cornwallis. Okay, so in 1793, when you discuss in history about the Cornwallis Code or the judicial reform, you will be talking about this rule of law, equality before law, etc., which were actually introduced by the Governor General Lord Cornwallis. So it is directly again from UK. So even the Governor General also have to work within the law. That's what you mean by rule of law. So rule of law, the rule of the land is supreme, not any individual, not the Governor General, okay, not the President, not the Prime Minister. Everybody have to work within the law. So rule of law. What about process of lawmaking? Process of lawmaking again from UK. Parliamentary system, UK, but there is a small difference in the parliamentary system. Okay, there it is monarch, which is not elected, which is hereditary. Here the head of the state will be president, which is elected, and it is republic. Okay, so I'll discuss that in the coming session. So anything more apart from this, like single citizenship? UK. What about republic? Republic from France. Okay, so procedure of working of Supreme Court. Working of Supreme Court from where? From Japan. What about fundamental duty? Fundamental duty, USSR. Okay, and then when it comes to the constitutional amendments, I will be discussing about how the constitution is amended, what is the procedure, what type of majority is required, or everything we'll discuss. But you will see there, when there is an amendment, there will be, if it is affecting the state, okay, otherwise also you need 2/3 majority. Okay, special majority. From where? This is from South Africa. Okay, so go through all these, because you can expect a one-liner, and one-liner, guys, in polity, if you're getting, you are lucky, and you should be knowing that there is no confusion. They are not going to create any confusion over there in those kind of question. Okay, apart from this, what about impeachment of president? Impeachment of president from USA, right? Single citizenship, UK, we have discussed. Impeachment, US. What about election of president? Election of president, any idea? Any idea? Election of president? Ireland. Not USA, Ireland. Okay, impeachment is, I'll discuss election, what is the election procedure, who all will participate, how the impeachment of president is done, and everything we'll discuss in the chapter of president. And chapter of president, that is one of the most important chapter in polity. Okay, so all powers of president, everything will be covered. So election of president, Ireland. What about preamble? USA. Okay, what about judicial review? Judicial review, USA. Because see, in UK, constitution is not supreme, so judiciary is not that powerful. Judicial review is not that powerful over there, because it is a parliament which is supreme when it comes to UK. Okay, so that is why judicial review is actually from US, and that is why we are, all these fundamental rights and all these are intact. Otherwise, parliament can bring laws which can curtail the fundamental right, so that will be difficult. Okay, so judicial review. What about again, independent judiciary? When I say judicial review, it also part of independent judiciary. Especially, guys, independent judiciary is very much important in which type of system? In federal setup, right? So since we are having a federal setup, there can be disputes between center and state. So obviously, what you need independent judiciary. Okay, so that is also from US. Okay, so now one of the other power of president is actually, he is the chief of armed forces, or he is also the supreme commander of armed forces. So president as the supreme commander of armed forces from which country? Again, US. Okay, So president as the, what do you mean by this? Everything we will discuss in the chapter of president. Then vice president as ex officio chairman of upper house of the parliament. So vice president, vice president is drawing salary not as vice president. He is drawing salary as the chairman of Rajya Sabha or the upper house of the parliament. From which country? Again from USA. So vice president is actually the ex officio chairman of the Rajya Sabha, okay, upper house of the parliament. What do you mean by this ex officio chairman? Because you are the vice president, so automatically you will be this. That's what you mean by ex officio. So you are this, so because of that you are that also. Okay, when you are in this power, so whoever is coming into this position will be the head of this also. That's what you mean by ex officio chairman, ex officio member, like that. Okay. What about federalism? What about this? Just before I've told you 1935 Government of India Act, right? But federation with strong center, if that is what I'm asking, then Canada. Okay, so federation with strong center from Canada. What about this residuary power with the center? Residuary power with the center, from where? Canada. Okay, residuary power from the center with the center, that is also Canada. What about concurrent list? Concurrent list, Australia. Okay, so like this, if I have missed out anything, I have missed out so many other important points also, might have. So there is no point in discussing all these facts. These are, you may consider these as GK questions as well. So there is no point in discussing these facts. In fact, I'm more interested in discussing the concepts. Okay, so we will be doing that in the coming sessions. So which one is the most or the lengthiest constitution of the world? Indian constitution is the lengthiest constitution in the world. The reason I've told you yesterday. Why? Because you see 60% is from 1935 Government of India Act, right? But this itself was so bulky and so big. So obviously the Indian constitution was lengthy, and we have drawn considerably from all, all nation states or all states, all the good procedures and all the good things from different other states. What are the reason why we have done that? Because India is a diverse country. Okay, so we need to incorporate the demands and aspirations of different sections, different religion, different region, different caste. So we have to incorporate the aspiration, different states, region, language. Okay, everything has to be incorporated in the constitution. This kind of problem you may not see in any other country, this kind of diversity that we have. So obviously this is going to be a very lengthy constitution. Originally, how many schedules? We will discuss all these again later also. 8 schedules, now 12 schedules. Okay, articles 395. Okay, now there are sub articles which were added later. If you incorporate all these, around 450, 455 are there. Okay, then what about parts? 22 parts. Now if you include the sub parts, so it will become 25. What do you mean by sub parts? For example, this part 4A, which was added later. What is this part 4A? Any idea? Anyone? Part 4A is fundamental duties. Yeah. Similarly, 9B, all these are added later. Similarly, articles like this 21A. What is this 21A?
Right to education.
Education, elementary education. Okay, that is becoming the fundamental rights. So you can see whatever is added later, that is what you can actually see in the capital letter. Okay, so if you see some articles with the capital letter, this is something. What does that mean? It was added later to the constitution. Okay, so now what we will do, the next thing that I need to discuss here is this one, objective resolution. So what is this objective resolution? Objective resolution basically shows the philosophy of Indian Constitution or the idea of the constitution makers or the nationalist. Okay, so objective resolution. Guys, I will not be getting time to go through each and every point, so I'm not going to do that. Instead, I will recommend you to read from the Lakshmikant. I'll tell you the crux of it, and that is enough. Understand that, and whatever is required, you can just take down also along with me, and then go through the Lakshmikant. Things will be more clear. Okay, so who proposed this? Pandit Nehru, right? When? In the first session of Constituent Assembly. So I've told you when was the first session. When was the first session? 13th December 1946. And it was adopted on 22nd Jan 1947. Okay. So he highlighted some points. That means, see, this is all about how the constitution should be. Because, see, the Constituent Assembly is formed and you're going to make the constitution. So how it should be and how it should look like, what all things has to be incorporated, everything that the philosophy of the constitution in one single line, if you need to explain, that is what objective resolution. So based on this objective resolution only, the constitution is actually prepared. Okay, so if you see, India is to be an independent, democratic, sovereign republic. So this is one of the just let me write democratic sovereign republic. So this is one point. Okay, similarly, it should provide fundamental rights. Okay, like instead the words used are like this: the freedom of thought and expression, that you can see as a fundamental right. Okay, belief, so that also you will see in the fundamental right. Belief, faith, worship, vocation, you can see in the fundamental right, association, actions, and everything. So that is one point. Okay, so all these freedom of association, freedom of occupation or vocation, freedom of faith, freedom of belief, freedom of association, everything is actually there. Similarly, this one, protection of minorities or the safeguard minorities. Okay, minorities, backward and the tribal areas, all these are incorporated. Minorities, tribe. Now, what do you mean by minorities? How many? What do you mean by minority? Those who are not majority is minority. Simple. Okay. So who's majority then? Hindus are majority. So who's minority? Everybody other than Hindus are actually minority. What are the two types of minority? You have linguistic minority and religious minority. What I have discussed with you now is the religious minority. What do you mean by linguistic minority then? If you go, so if you go to North India, the South Indians, those who speak Malayalam, Tamil, etc., they were minority. Similarly, it is again, relative, based on the situation, based on circumstances, it may change. Okay, so if somebody is from Bihar is coming to Kerala, he, even though speak Hindi, which is the majority language, but still he will become minority in Kerala. Okay, so like that. That's what we mean by linguistic minority. Religious minority. These are the two types of minority. We will discuss about all these provisions with respect to minorities and all in the coming sessions. Don't worry about that. Okay. But when we discuss about minority here, we will talk about two minorities: religious minority and linguistic minority. Guys, go through all these points, which is there in the objective resolution. You will get the idea. It's all about sovereign, independent India. So justice, social, economic, political. You will see all these in the preamble also. Okay, so freedom of thought, expression, belief, faith, worship, vocation, association, action, all these I've told you. Okay, so sovereign republic, various committees. Just go through all these. Okay, so it is not required to read between lines here in the class. That is something which you can do. What I need to do to explain this part, I've done that. So I'm expecting this will be very simple and you can go through that. Now, what I'll do is I'll briefly tell you the difference between written and unwritten constitution. Okay, what is the difference between this written and unwritten constitution? What about our constitution? Is it written or unwritten? Our constitution is written constitution. What does that mean? there was a body which was selected to make the constitution. They have drafted the constitution, voted upon, and that have been enacted and enforced from a particular date. But that's not the case with unwritten constitution. Unwritten constitution will keep on evolving over a period of time. In case of written constitution, everything is codified. Okay, the articles, the provision, you will see article 1, article 2, everything is codified in proper form, right? The schedules, whatever it is, everything. So let me write it here. Articles and provisions are codified in detail. Here, not codified. Okay, so here, when it comes to this written constitution, the constitution is supreme. Okay, here the parliament is supreme. So parliament keep on making law based on the changes in circumstances, based on the requirement, and that will become part of, that is what becoming the constitution, whatever laws are made. But that's not the case in this here. In India, if you need to make a law, it has to be based on the constitution. Any law which is, for example, violating constitution, violating any of your fundamental right, it will be struck down by the Supreme Court. But that's not the case here. If any law is made, that will become part of it again, and based on that, it will be continued also. That is what you mean by evolving over time. So unwritten constitution, it is not that very rigid, it is not that codified, it will evolve over a period of time. Okay, and here parliament is supreme. If parliament is supreme, what about the power of judiciary? Will be more or less? Or where the power of judiciary will be more? Here, in this case, judiciary will have more power, right? Because everything is written and everything is codified. So the Supreme Court will be there to look after. The main role of Supreme Court is actually to protect the constitution and the constitutional values. So that is very important. So judiciary will be more powerful here, not here. Here, parliament is supreme. Whatever laws made by the parliament, the chances of judicial review and all is very, very minimum. Parliament is supreme. That will, any laws made which will become the part of the constitution over a period of time. That's not the case here. Any law made in this, I'm talking about this segment, any law made, if it is not in accordance with the constitution, that will be definitely struck down by the Supreme Court. Okay, so this will be an enacted constitution. So this will be an evolved constitution. So it is not like a, so here what will happen? Enacted means what? Just before I've told you, there will be a constitutional body which was elected. They will frame the constitution. They will sit together. They will decide, and that will be debated. That will be put for vote, and then enacted, then enforced. But here, no such body is there. Okay, over a period of time, whatever laws are made by the parliament will be the part of it. Okay, so it comes over a period of time. So here you can also talk about judiciary, the role of judiciary. Judiciary enjoy wide powers here, because see, it is crystal clear that something which is written and something which is codified, these are the fundamental rights and these are the directives given to the state. So the court can objectively look into any law which is made by the parliament, and court can easily struck down the law if it is not in accordance with the constitution. But that's not the case here. Okay, as it is unwritten, as it is not codified, if tomorrow parliament is making a law, that will become part of the constitution. Okay, so the role of court, the judiciary, the power is very less. I hope you understood the reason here. Okay, now here, when it comes to this written constitution, there will be a clear-cut difference between, a distinction will be made between constitution and other laws. So these laws which are going to be made in the parliament has to be in accordance with the constitution. The constitution is supreme, so constitution will stand by, and the laws which are different than the constitution, and it has to be in line with the constitution. But here, the laws which are made will become part of the constitution. That means no distinction between what? Constitution and the laws which are made. Okay, now what about when it comes to federal and unitary? Federal system follow which one among this? If it is federal, guys, if it is written constitution, it can be for federal and unitary. Okay, both can have written. But when it comes to unwritten, do you think this can be applicable in federal format? If it is unwritten, because see, in unwritten, who's enjoying the power? Parliament is enjoying the power. There is no judicial power, judicial review. There's very limited. So this is mainly in unitary. Okay, so like UK, if you see, it is unitary setup. Even though states are there, but they are just the administrative wing or the arm of the center. They will only implementing what the center is saying, right? States are there. It is not that the states are not there, but that is unitary setup. Okay, so unwritten constitution only for unitary, or in unitary only this is possible. In federal setup, that is not going to be possible. Why? In federal system, there has to be clear-cut distribution of power. If you are giving the supremacy to the parliament and not to the constitution, what will happen? Parliament can grab all the power from the states, and there will be, that will be total destruction to the concept of federalism. So in unitary system only this you will see. If it is federal, it has to be written, and unitary also it can be written. Okay, so written constitution will be there for federal as well as unitary, but unwritten will be only for unitary, because otherwise there will be problems. And this is always flexible, right? Why? Because parliament make a law and tomorrow that will become part of the constitution. Here this can be flexible as well as rigid. Why it can be flexible? Indian constitution itself, it is a written constitution. Why it is flexible? Because there are certain things where some flexibility is given, right? So like you need some simple majority in certain cases. Why it is rigid? In certain cases you need some special majority along with absolute majority, etc. So in certain cases Indian constitution is flexible, and in certain case, okay, so I hope this part is done. What I'll do is I'll talk about rigid and flexible. Okay, what do you mean by rigid? What do you mean by flexible? What do you mean by flexible? As its name indicate, the changes can be brought in very easily, right? So changes can be brought in very easily, but that is not possible here. Okay, changes can't be done easily. It requires certain, special processes. You need some special majority. When I say typically rigid, you need special majority. That's how you can make it rigid, no? So here, when I say rigid and flexible, it's all about bringing the changes. Okay, so to bring the change in the constitution, if you say special majority is required, what does that mean? It is very rigid. But can we say Indian constitution is rigid? Indian constitution is a mix of rigidity and flexibility. In what way it is rigid? Indian constitution, if you see some of the provisions of the constitution, and if you need to change that, for example, something which is affecting the state, you need the permission from the state. Okay, and similarly, some of the provisions of the constitution like fundamental rights and all, you need special majority and special process need to be followed. So in that way it is rigid, wherever you need special majority. But there are certain cases like changing the name of the boundary of the state. See, even without the consent of the state, the parliament can change the name of the state, boundary of the state. Okay, so for this, and that too, you need only simple majority. What do you mean by simple majority, special majority? I'll just tell you now after completing this part. Okay, so Indian constitution is a mix of rigidity as well as flexibility. There are some provisions which you need special majority and can't be changed easily, so that is rigid. But there are at the same time some provisions, even guys, look this, state's name and boundaries you can change with simple majority, even without the consent of the state. That means it is almost very flexible, right? But federal constitution usually the federal constitution will be rigid. Okay, but Indian constitution is a mix of rigidity as well as flexibility. I'll quickly go through this majority concept also. So because in the coming sessions we'll be talking about all these different types of majority. So what do you mean by simple majority? Okay, See, simple majority means more than 50% of present and voting. For example, let's say we have 50 students in the class, but how many are attending the class? What is, okay, so that is simple majority. Then absolute majority. Absolute majority means, let's say 50 students in the class, more than 50% of the number of students in the class. So, for example, in the parliament, if you see, how many are there in Lok Sabha? Lok Sabha, 545. Rajya Sabha, 245. Okay, this many member of parliaments, MPs are there. So when I say simple majority, more than 50% of present and voting. Absolute majority, more than 50% of the house. What does that mean? Here in this class, 50 students have joined. Okay, so the strength of the house's class is 50. But at this point, how many are attending? Let's say 29 are attending. Okay, so when 29 are attending, when I say simple majority, more than 50 of this 29. What is that? 15. This is what simple majority. If we need to pass something, when I say simple majority, whoever is present and voting, out of this 50%, more than 50% of present and voting. Okay, what about this one? 50% of the house. That means 545, 50% of 545. Okay, that is 273. Similarly, in this class, if you see 25 plus 1, 25 is 50% plus 1. So it doesn't matter how many is present and voting. Even though 29 only are presenting, when we say absolute majority, it is 26. And guys, this one is not used standalone. You will not see absolute majority alone. It will be used along with something, some conditions like special majority, 2/3, and then absolute majority. Like that only you will see. So simple means whoever is present and voting 50% or more. Absolute means out of the total, which is the strength of the house. What about Rajya Sabha? Divide by 2 plus 1. What is that? 223. Okay. So 223. What about Rajya Sabha? 273. Okay. Now, even though 545 are there, let's say 520 are present. 520 are present. Okay, normally that won't be there. 450 will be there, or 350 will be there. 520 are present means what is the simple majority? 261 will be the simple majority. I hope this is clear. Then what about effective majority? Effective majority. Effective majority means not less than 50% of total. Right? This is what we have understood as absolute. Right? More than 50% of total. But here not total. Total minus. See, when I say total, Lok Sabha 545. But in this 545, there will be some vacancies. Right? So some of the members might have resigned. Some of them might have died. Or some of them might have disqualified by Election Commission or Supreme Court. Okay. So what we need to do here, vacancies in the house. This we need to exclude. So for example, 545 are there and 5 vacancies there. So what do you mean by effective majority? 540, half of that, 270 plus 1, 271. This is what effective majority. Absolute majority means 545 majority, that is 273. Okay, so absolute means it doesn't matter whether vacancy is there or not, total house. Simple means those who are present and voting. See, let's suppose, guys, for 545, 450 are present. And out of this 450, maybe 5 people might have gone for, for bathroom also. So they will also not be part of it. Then, see, present and voting. So let's say 450 are present. But at the time of voting, these 5 members went outside for loo or for bathroom. Then how many are there? 445. So what is the majority? 223. I hope this is clear. Then what do you mean by special majority? Constitutional amendments, some cases you will see special majority. So special majority means 2/3 of present and voting, 1, B, then plus absolute majority. Okay, so 2/3. What does that mean? let's say 545 is the total of the house. So here absolute majority means what? More than 50% of 545. That means 273. So absolute majority means 273. Now out of this 545, let's say 400 is present. Okay, only 400 is present. Now what do you mean by this 2 by third? Or not for, let's take 402 are present. Okay, let's say 402 are present, or 420 are present. Okay, so now you will see 2 by third. Okay, so more than 50% or more than 2 by third. See guys, this is nothing but 66%. Earlier I'm talking about 50% of present and voting. Now 66% of present and voting. That means you need more numbers, right? So it is nothing but 140 into 2, it will become 280. So 280 is what actually, what do you mean by 2 by third of present and voting? If let's suppose 420 are present, 280 is what the 2 by third. So you need 281. At the same time, you need absolute majority. That means 273. So when you are getting 281, then anyway, it will cross 273, not a problem. Okay. For example, if you have 360 only are present, only 360 are present, then what is 2 by 3? 2 by 3 means 120, 240, and what do you mean by this? 240, right? Okay, so this is what special majority, 2 by third. So 240 plus 1. At the same time, you see here, this is 273. So you need more than 273 anyway. This 241 is not enough when these two are clubbed together. 2 by third majority plus absolute majority, when it comes in that way, you need 273. So when less number of people are present, you need to reach to 273. That is slightly difficult. More numbers are there. Like in this case, automatically, if you're getting 2 by third, that is more than 273, then it is fine. Effective majority means confusion. Why it is a confusion? 1 by 2 of total. What is that? 545 minus, there will be some vacancies. Total membership. It is a total strength of the house. 545, let's say vacancy is 5. Then 540. Half of that is 270 plus 1. More is required, so 271. Okay, so since 5 vacancies are there, we exclude that. This is what effective majority. Absolute majority means what we do, this won't be there. Half of total. So 545, half of that 272. So plus 1, 273. So absolute majority will be 273. This is total strength of the house, more than 50%. Effective majority, total minus that vacancies. Might have died, might have disqualified, right? So, or it can be resigned, any reason. Yeah, guys, any doubt we can discuss now. I was not able to complete this federal unitary and as well as this something more I wanted to discuss today. Yeah, federal unitary, that I will do next session. Any doubt? Guys, next session will be on Monday because I will not be able to take class for next 2-3 days. In case, if before I can take, maybe on Saturday or Sunday after the Christmas, I will let you know in the group. But as of now, just keep it for Monday, and from Monday onwards will be regular because tomorrow onwards I will not be able to take for 2-3 days. So we cannot have class tomorrow. And this video I will arrange within 2-3 days. By the end of this week, you will get all the videos as well. Any doubts here?